is to have me as the face on the thing when you go to actually log in or just view from the village websites. And I really can't stand looking at myself. So I figure if I don't turn it on until it kind of starts, then
You're
I might
on
not be
YouTube saying this, Jane.
I know. Well, I feel the same way. I don't like having my picture online, so.
But you're gonna turn it on, right?
Yes,
Okay.
there.
There you go. Xander BW needs to turn on his video, please.
Dave,
Yes,
Video?
please turn on your video.
I thought I had it on there. Let me see. Is
There you go.
that better?
Yeah,
Yep.
sort of, except you can only see the top of your head.
So we're waiting for
Okay.
Georgia before we can open the meeting.
Correct. If you have to have
Okay.
3 to do it, yes.
Yeah, I think we have to have 3 to open it.
There you are, Dave. Robert Birch.
So I'll send Georgia an email right now and just say, kind of, you're almost here.
Oh, you're almost here.
So Susan, you have to have a quorum to even officially
I think so. In
start
order
a
to,
meeting, is that how it
in order to
works?
have a meeting. Yeah, I believe so.
Okay, I don't know, that's why I'm asking.
And we certainly can't go very far, even if we opened it without a third
Right.
person.
When we start, which item on the agenda are we starting with?
14 Pioneer,
Okay, so that's,
but we may not make a decision since Marcy's going to join us. We'll see. We'll talk about it. But I think we'll just go in order.
so probably what I'll do is I'll mute Bob Birch, and normally I'm going to turn off your video, and then when it's your turn, I'll ask you to start it, and then Celia needs to turn her video on. All right. So I'm gonna mute you, and
There's
here's
Georgia.
Georgia.
Hi.
Hi, Georgia.
Oh. Hi, how's it going? Sorry.
Good. How are you? You just moved in my screen. How are you?
Good, how are
Welcome.
you?
Okay. Good. You make our quorum. So the time is 5:03. I'll open the October 2020 meeting of the Zoning Board of Appeals. We have 3 items on our agenda. And the first is a continuation of our decision on 14 Pioneer Street. Even though we have 3 members here, which is what's the minimum required for a quorum to be able to open up a meeting, we are expecting Marcy to join us probably in the first half hour or so. So I don't know, since she was at the public hearing, and I don't think Georgia was, I mean, she's more familiar with that. So we may just kind of update Georgia and then potentially wait till Marcy can join us to kind of weigh in on any further thoughts in that decision. Georgia, I don't know if you've had a chance to look at both the minutes and the file for that, if you have any questions.
Briefly, but no questions so far.
Okay, all right. Does that make the most sense to just wait for Marcy for this, do you think?
Probably, because otherwise you need a unanimous vote, right?
Right, it's definitely better for the vote, but also just for more, she has much more background on the, on the last meeting.
So
Okay,
just to let Georgia know, the original application came in with a 2-foot variance request. After the last meeting, I actually went out and measured the potential location, and per the drawing that was in the application, it now looks like it's roughly 9.5 inches to 10 inches for the variance for the location of the one corner of the column for the gazebo. So,
it's like a little triangular
yeah,
space that needs the variance because the building is not parallel to the side property line. Their hot tub is not in the proposed building.
so,
Okay, I think what we may do then is, Celia, is wait till Marcy, we'll just kind of hold this and get back to it as soon as we have an opening after Marcy rejoins us.
Okay.
And so we'll move to number 2,
I'll just,
15 Hill Street, a preliminary meeting. This is a request for an area variance to allow required off-street parking in the front yard setback. So if you, okay, there's Normandy.
okay.
How are you?
Good.
Do you want to just give us a simple overview of your situation?
Yeah, so I would have liked to have put a driveway that could have gone further back on the other side of that house. However, there's a stormwater drain right at the, you can't see it on that map, but there's a stormwater
Right,
drain,
there's-
yeah, right down there. Where like looking at the overhead, that looks like it would be a great place to put a driveway back in there, but it's too, you can't have the stormwater drain and then get up to the sidewalk and then up into the yard from that side of the house at all.
Mhm.
However, in that other corner of the house, which is why I divided that property the way I did, you could put easily a 2-car parking spot there. I know that is the front of the yard, but I think it's way preferable to have the cars parking there in the yard instead of right on the street, which is where they park right now.
Okay,
So yeah, when I'm getting the other excavating done on the lot that has the garage, I thought I'd ask the excavator to put in just a simple gravel driveway in that spot, which would be much easier. So
okay. And there is a storm drain on that side too, but it's much closer to the house.
There's actually 2 storm drains. There's one, if you can see my moving cursor, somewhere right around there. And then there's another one like right there. So it's on either section of this curve.
But
Um,
the level of the road to the sidewalk is much closer to the same, whereas down on the other side of the house, they're significantly different. The sidewalks are
And-
raised above.
And both Mitch and Cindy, who's the chair of the streets committee, are aware of this, and they did not express any concerns as far as the location of the parking in regards to the storm drains.
Okay,
So,
so this parcel was recently subdivided?
Yes.
correct.
Okay. This drawing that's on the screen at the moment helps, but I think what we need to do is have you draw 2 scaled spaces. Because it's still going to be tight for 2 parking spaces. They have to be 9 by 18. And I know you have a bank there near the side property line.
Yeah, that garage is a 20 by 24 building. So that gives you a little bit of a scale.
Right,
So it's 24 that way.
Oh, sorry, 20 by 22.
Okay.
wider than it is deep.
Yes.
Okay,
So that's this is roughly 20 feet, or it's more than 20 feet this way. I'm just not sure
right.
distance wise that way.
I just think it just needs to be drawn on the drawing
Right.
where the kind of cloud indicates the
Yeah.
general area. And because it is going to require some kind of I don't know if it's a retaining wall or some kind of bank on the side property line, but you know, that will kind of, it won't be able to go right up to the side property line, I don't believe.
No, there's a little hill there already from like, maybe 10 feet out from that garage, like right around where that property line is, there's a little bank that goes down into a flatter area. And when I talked to Scott Ubner about it, he thought it didn't need a retaining wall at all. He would be able to grade it all, flat and he thought there was plenty of space for 2 cars.
And Susan, on this plan, if you look at it, this dash line is the 20-foot offset from their property line.
Right.
So
So are you,
it looks like you can definitely get, if you flare it, you can definitely get the 9-foot spaces. They might come to,
Mhm.
it might be
Start- so-
tight and it might be closer to up here, closer to the property line, but that's where it is.
but it basically will have to start right at the front property line?
Probably, yes.
Okay,
And
All
like I
right.
said, they had gotten permission from HPAR couple of years ago, I believe it was,
Yeah, 2 years
probably
ago.
to put it here. And then it wasn't until, we started looking at all this situation with the catch basin, basically right here, there was a quite considerable grade
Mhm.
change from the street to, this area. So they just wouldn't be able to accomplish that. So.
okay. I just need scaled parking spaces shown on a proposed plan.
Yep, we can get that done
Okay.
in the next couple days and get it back to you.
All right. And so if you can give Normandy a copy of the criteria to fill out.
Yep, I will.
And does anyone else have any questions? Okay, then we'll set up a public hearing for review of this area variance on, are we gonna have a meeting on election day? Is that
We've always done it before, so,
Okay. on election day? Whichever
I
that
mean,
is.
at this point, it's, I would assume that the online stuff is gonna be extended, but I'm not positive.
Okay.
Like I said, he waited till yesterday to extend it for this month, so.
Okay,
Yeah, that was
so
great.
so November 3rd, and it'll either be Zoom like this or else we'll start in-person meetings again. All right, thank you very much. If you'll just provide that plan before then and those criteria, Jane will send the notifications around to all the adjoining properties, and then that takes care of all of our background work.
Great, thank you.
All right, thank you.
Sue, is that going to be a public hearing?
Yep, area
Yes,
variance, yep. Okay, I think we're still waiting for Marcy, so we'll move on to number 3. 194 Main Street. You want to add Bob and
Yes, to unmute
Shawnee to the video there? Hello?
video. Yes,
Hello, and we have Dana as well.
Hi.
yes, to start video. There we go. No, it's wrong. Hello, hello.
Bob Birch.
Bob, can you unmute and put on your video?
Okay, start, there we go.
Yeah, not,
There he is.
yeah.
Okay.
I've never been on the receiving side of a Zoom conference. I'm usually setting it up. So
Ah,
now I
Now
know
you-
what my
Now you
clients
know how
are
we feel.
suffering through on the other side.
Right. All right, so this is a kind of different application than we're used to. I don't know if everyone's had a chance to look at all the background information that was sent. And I presume that the Sanders have some kind of purchase agreement for the project, so they have standing for this?
They do.
Okay. All right, so Bob, do you want to summarize and then we'll see what we do from here?
Okay, so as laid out in my my letter, I just wanted to review the background. In 2015, well, first of all, the building currently is owned by Bob Schlatter and me under an LLC or a LLC, Cooper Country Properties. But we're the only 2 owners of the property. But Marcy, my wife and I decided that we wanted to start renting out our own home in Hartwick for summertime rentals, in addition to other properties that we've got on our property out on Greeno Road. And we also thought it might make some sense to rent out the first 2 floors of this 3-floor apartment building. But we knew that we needed to have owner occupancy of that to do that. So we came before this board in the fall of 2015 and applied to be allowed to rent it out on a weekly basis during the summer months, with the intent of renting it out during the school year to graduate students or traveling nurses. And we've never had any problems keeping it fully occupied, with a combination of both. Last year, it was entirely students from the Museum Studies program. But we would move into the 3rd floor and rent out the first 2 floors. We received a special permit for that, as I pointed out in my last email to Susan and the board, had no termination date. And in fact, as part of the agreement, we said that we would give an easement to access the backyard over and across the property at 196 Main, which is another building owned by Cooper Country Properties, Bob Schlatter and me, where we run our abstract company. So we did record a permanent easement as part of the parking plan for this board, and that's of record, that allows for access to the back in case that's necessary for additional parking. But the idea being that if the properties were severed at some future date, there always would be sufficient parking for the back to support the parking requirements. This has gone swimmingly for the last 5 years. I'm sure that Jane has never received any complaint from neighbors about the activities at 194 for our summer rentals. But we had an opportunity this year to sell the property, or decided to sell the property. Marcy and I are getting a little tired of moving every year. So we're in contract right now to sell it to Dana and Shawnee. And they're a young couple who are looking to start the home ownership process. Shawnee, I don't know if you want to jump in and share what, has been your experience in terms of trying to find affordable housing in Cooperstown, but that's one of the great needs of this town, is how do you get young people to own property in the village?
Yeah, Dana and I started. Yeah, Dana and I started really looking in earnest this spring, and a lot of beautiful houses on the market, but we did find the pricing of housing to be quite expensive. And just the thought of moving into town was really exciting, but of course, with a large mortgage payment, that's also, a challenge these days for a lot of people. And so just, the thought of a multifamily, which, could help actually kick off a bit of extra income in that a short-term rental could be quite lucrative, and, actually really enable us to have some extra liquidity in the building and be able to update the units and replace the roof and fix the front porch, and, really, keep on top of the building while not kind of drowning in mortgage payments. That was, very appealing. And so that sounds exciting to us, and would be lovely if it could be extended along.
Thanks, Shawnee. So we've got from a public policy perspective, the long-term housing needs shouldn't only be focused on rentals. We'd love to see, ways of allowing home ownership. And I know Marcy and I started our home ownership life with a duplex where we did this. So this is a building that allows them to live in the top floor, which is their plan, and rent out the first 2 floors. As I laid out in my letter in support of this application, I do find this latest revision in the law to be rather curious, making a distinction between a 3-family and, quite frankly, a 2-family if you're allowing this to be done in this zone. The use is allowed in this zone for short-term rentals. It's just not allowed in this type of building. It could be done in a home that has also has a separate kitchen and even entrance, which would essentially be a duplex for all intents and purposes. But so I find that to be somewhat of an arbitrary and capricious distinction. But most important is that the zone, and I don't know to what extent the ZBA has authority over looking into this, but the zone for this block really, I think, needs to be re-examined because it really is a business district. It's not a residential business. I was just looking at the tax map for all the properties. Obviously, this property is surrounded on all sides by businesses. The law office on one side, the abstract company on the other side, and the entire opposite side, of course, is the Otsego County building complex. But if you look at just the south side of the street alone from the traffic light up to Railroad Avenue, there are a total of 13 lots. And of those 13 lots, there is only one residence. I'm not quite sure what is being done with the property that had been owned by Tim Johnson, but I do know that he got a multi-use permit for that at one point. So it may have reverted back to strictly a full-time residence now, but it at one point was a mixed-use property. But otherwise, you either have businesses or commercial entities on the entire opposite side of the street. And from Nelson Avenue until you get to Bruce Hall, there is only one truly residential building, not counting the 4-unit apartment building that's next to the abstract company. So it seems to me that this is an area that's crying out for perhaps an area variance, for lack of a better way of looking at it, because the use is allowed in the district.
It's
But
only allowed by special permit, though. It's not a permitted use.
pardon me?
It's only allowed by special permit, not a permitted use.
Okay, so, well, in any event, because it's essentially that type of building, a weekly rental is allowed in that type of, in this block, in this district, in any type of building, regardless of whether it's a 3-unit or a 2-unit building. It seems that it would be appropriate for this area, and in fulfillment of noble long-term goals for the village, for property ownership, for young families who can't otherwise afford most of the housing stock in the village. And it supports other aspects of the housing needs of the village, including short-term rentals. Our graduate students are thrilled to not have to pay rent for an entire calendar year. And many of the traveling nurses who rent from us or would rent from the buyers also don't want a full year. So there is a need for that as well that's served by this building.
Okay. Just to kind of clarify things, the distinction between short-term rental and long-term rental is 30 days. So monthly rentals or, up to a year or, obviously longer are all in one category, and anything less than 30 days is what's regulated much more strictly through the special permit process. In your application, you basically asked for a continuation of the existing special permit. I personally don't see how that can happen the way our law is written. I don't know whether anyone else has any other perspective on it, but the last revisions very specifically said that when there's a sale of more than 50% of or a change of ownership of more than 50% of the property, 50% change of ownership, excuse me, that that basically things revert back and you have to kind of comply with all the current regulations and go through the process again.
I realize that the board is kind of stuck with that.
Mm-hmm.
But my argument certainly would be that I think that's subject to a constitutional challenge. There's no phasing out of that under the law as there was with the non-owner occupied amortization over a period of years. And I think there's a line of court cases that say an attempt to, we have a legal pre-existing non-conforming use essentially that is attempted by the zoning law change subsequent to 2015 to terminate it just upon a sale. And I'm not sure that that would surpass court scrutiny, but I really don't want to take it there because I think there are a lot of better ways of looking at the problem and coming up with a reasonable solution.
Okay,
I did talk to the village attorney about that, and I think he realizes that it's not one of the strongest parts of the current zoning law.
nevertheless, we have to work with what is the law.
Right.
So I would say that we can't continue the existing one if there is a change of ownership of 50% or more than 50%, I guess is the term. So then basically the question would be whether you, and it would not meet a new special permit requirement because of that situation with the 3-family as opposed to 2-family. So it would require a variance of some sort. It's a very strange kind of application. We don't have any history that's similar to it. And the question of whether it's an area or use variance is a legitimate one to me. I leave it up to Jane to kind of make that initial determination, and we'll kind of work from there. But that's kind of the path that I can see. I don't listen to whatever anybody else has to offer.
Lacking anybody else offering anything, not to jump, but again, I did talk to the village attorney on this, and he really thinks that it is most appropriately defined as an area variance to the extent that it's a variance, because he agreed with me, the use is allowed in the district. It's just the building in which the use is being allowed is different than the code requires.
Okay.
Right. And that's why if you look at the agenda, I had listed it as needing 2, decisions. One would be a variance from the single family requirement, which was section 317, 1B, 1A. And then the second one would be the actual application for a short-term rental special use permit. So it would be a variance for the from the requirement of a single family house. And if that was granted, then it would be, continued on to the special or short-term rental special use permit.
Okay. All right. Okay, so we will address this as an area variance. I'm sorry. Okay. Okay, we'll approach it that way. So we'll set up a public hearing for an area variance for 194 Main. It'll follow the one at 15 Hill Street on election eve. Probably the 15 Hill Street won't be very long public hearing, but so we'll set it up. Pardon? I keep hearing somebody.
I think there's feedback, Susan. I don't think anybody's talking, but
Okay.
for some reason it chirps. I'm hearing the same thing you're
It was
hearing.
like a squeak. Yeah. Okay. All right. So we'll set up an area variance public hearing. I would say though, and Marcy will be able to kind of weigh in on this too. Both Marcy and I served on the works on the study group that went through all the changes that were most recently passed. And it was very intentional that the point of all the changes was to recover rental housing within the rental units within the village that had been allowed to become short-term rentals, because the greater need seemed to be for long-term rentals. So I think that it will have to, it would be good to kind of like for everyone to fully understand the kind of background of why these changes were made, because I think they were very intentional. I'll also say that when we reviewed the map, I suggested considering rezoning that section of Main Street and particularly on the south side of the street, because that's even more obvious than the
Right.
north side has a lot of residential still and residential character. And I did not succeed.
Well,
But
that was a noble effort. We can retry that.
it was definitely discussed though. I mean, because the entire map, a lot of the lines were redrawn, the numbers of residential zones were simplified, and, there were significant changes, but not to the, location of commercial or business district, no expansion of either of those.
Yeah, it just seems kind of ludicrous to have the entire county complex sitting right in the middle of a R3 zone. And when 90% of the tax map lots are in fact legal pre-existing non-conforming uses, it's like cries out for rezoning.
See, I don't really see them being quite as extreme as your map showed myself. I think the one up on the corner of Railroad and Main, I believe that is a residence. And
I think it's mapped in a commercial zone, I guess.
Right, but
I'm
the
not
use-
sure whether it's being rented out or not, but and
yeah, I
next to
think
that, of course, is the accounting practice, and next to that are the insurance buildings, and next to that is the greenhouse. And
and then there's two houses. Well, after the house is attached to the greenhouse,
right.
and there are two residences. And one of them did get a use variance at one point, but I've never really seen any evidence of it actually being anything other than a residence.
It had been used by Tim Johnson as law office, but I think only maybe for 4 years or so.
Okay,
As his
and that's
Cooperstown
quite a
branch.
while ago, right? And the other side of the street, other than the two Schlatter and Birch properties, it really is residential, whether it's, 3-family, 4-family, B&B, it is pretty consistently residential, or more consistently
Yeah,
residential. But it is a transitional space. I agree with that. Okay, so we will set up the public hearing for November 3rd.
Susan,
Yes,
question. We've done this before where we've had a situation where it was a special use permit that required a variance to proceed, and we've scheduled both public hearings for the same time with the understanding that as long as if the variance got denied, then that was an automatic denial of the special
Yeah.
use permit.
I think we would do that, just do them sequentially and address the variance first, and then if that,
So the public hearing is for both the short-term rental, okay. I just wanted,
Okay, thank
we're
you.
talking about just the area variance, and I just wanted to make sure it was gonna be for
No,
both of them.
no, that's just the most critical one, actually,
Okay.
so you'd have to send out your notices according to the special permit requirement, which is far more extensive than the area
Correct.
variance requirement.
But
Okay,
are you basically scheduling 2 consecutive public hearings?
Yes,
Yeah.
yes.
actually, that's true,
So there'll be 3 public hearings at next month's meeting.
right.
Just for the benefit of Dana and Shawnee, obviously they've got a mortgage application process that they're following through on the purchase as well. And we've got time constraints on their interest rate locks and all that kind of stuff. But do you then take a vote immediately following the public hearing? Is that the procedure?
We most commonly do, but we have up to 62 days. It's pretty unusual that we don't make a decision that evening. A little bit would depend on how many people we had on the board, and, because we also have to have both 3 members to open a meeting, but also 3 in the affirmative to grant any kind of variance or special permit. So it is advantageous to have as many members present as possible
Yes.
for your benefit. So I would say it's most likely, but it can't be guaranteed.
Okay. Thank you.
Mhm. All right, anyone else have any questions on 194 Main? All right, I think we'll go back to 14 Pioneer and talk about that and see if we can make a decision without Marcy.
The
Thank
only
you.
thing is I'm
Thank you for
looking
your
forward to
time.
having you guys as neighbors.
Thank you, Georgia.
All right,
So should I turn on, ask Celia to turn on?
yeah, turn Celia back on.
Okay, guys, not to be rude to you, I'm gonna turn you guys off. 'Cause I'm supposed to do that. That has nothing to do with you.
All right,
Goodbye.
thank you.
Bye.
night.
All right, so start the video and we should be good.
Bye, thank you.
Bye-bye. Hi, how are you?
Good.
I thought by now that Marcy would join us, but she hasn't been able to yet. So we're gonna go ahead and kind of start a discussion and see where we go with that. I guess my only question was in the way that Jane showed the plan, she showed it both as you requested and as it would have to move without, in order to not require variance. What is the reason why it can't just move? Celia,
What do you mean? It can't just move?
do you want to put that picture up, Jane? So
Sure, hold on one second.
This one. So the open squares show the request, and that's what requires the 9.5 inch variance. The dark squares showing the location of the corner post pushes it in 9.5 inches, obviously, so that it meets the setback. What is the reason why it can't just move into the, to be outside of the setback line?
Just because aesthetically, it's going to be look better. It's going to be centered on the hot tub. It'll give us more patio space. And it doesn't amount to hill beans. I mean, it's not going to affect anybody's property values or anything. It's just, it will have more patio space. Well, it'll be centered on the hot tub.
Keep the snow off.
So that we can keep the snow off better. The concern is when you open when you take the cover off, it hangs over the side, and it would give it better protection when it hangs over the side in the rain or in the snow.
So it hangs over the long side, the property line side?
It does.
But it doesn't touch the ground.
Okay. Does anyone else have any questions or comments? Okay. Marcy's our kind of go-to person for motions. But if anyone's ready to make a motion, Dave or George, I'll entertain a motion.
I'll make a motion.
Okay,
I'm not sure of how to word it, but I now that's just such a small amount, I agree that to allow her to get the variance she needs for that.
okay. I would describe the variance as part of the motion.
Okay.
So, I'll just add and then like, so a 9.5 inch, a triangular space, 9.5 inches by 8 feet 3¼ inches per the plan.
Correct.
And so it's a side setback variance at 14 Pioneer Street. Then the only other thing I would suggest you may want to add, because it's consistent with our carport review a few months ago, is that it's granted for an open-sided
Right.
as proposed. So it's an open structure.
Yes.
So I'm going to ask for a second and then ask Michael to read that back.
I would second that motion.
Okay.
Georgia seconded.
Yes,
Yes,
Georgia.
yes.
Okay, so it's a side yard setback variance at 14 Pioneer for a triangular space 9.5 inches by 8'3¼ inches as per the plan submitted and granted for an open-sided structure only.
Okay,
Is that right?
Correct.
Okay,
I think that's right. Captures it all. Okay. So there's a motion, there's a second. Is there any further discussion?
that Marcy?
Oh, yay. Oh, let's
Yes.
wait for Marcy for a minute. Marcy, we can't hear you and we can't see you yet.
Asked her to, no. I will ask her again. And ask to. Her connection may not be very good or any good.
Okay. Do we want to go ahead and vote?
My guess is if Marcy's trying to sign on, she'll be unhappy if you.
Oh,
There
there
she
she is. Yay, yay.
Marcy,
Just-
you gotta unmute.
Can you turn on your microphone, Marcy? We see a still version of your
I'm
face.
here. You
Oh,
hear me?
sort of. You can sort of hear you.
Pretty echoey.
There
There
you
now.
go.
I think
That
it's
looks a little
better.
better.
Okay,
Yes,
Yep.
much better. There you go.
I'll try and get closer to the internet.
Thanks.
Sorry about all this, everyone. I'm sorry.
This is just in the nick of time, Marcy. We deferred decision on 14 Pioneer, thinking that you'd be able to join us later in the meeting. So we've gotten back to that.
Mhm.
There's been a motion. I'll have Michael read it again, and we're just about ready to vote.
Okay,
The motion was to grant the side yard setback variance at 14 Pioneer Street for a triangular space 9.5 inches by 8'3¼ inches as per the plan submitted, granted for an open-sided structure only.
okay, we have to go directly to a vote, or can I ask a question?
No, you can ask a question.
Can you summarize the discussion
Um,
in 10 words or less?
I mean, it's been a short discussion since we spent so much time on it in other meetings.
Yeah.
I'd say the only question I asked was why it couldn't be shifted the 9.5 inches. Celia explained that it was because of the cover opening and
Mhm.
along that side and keeping it protected from snow.
Okay,
And I believe that was the only question and further discussion, wasn't it?
okay. Okay.
Okay,
Mhm.
so we're ready to vote?
Yes.
Okay, I'll just go around and say your name and what your vote is, please.
Oh, me, Marcy? Yes.
Okay,
I vote to grant. I think that's the way it was worded.
Yeah,
Okay.
Dave,
Dave Wood, yes, I agree.
Georgia,
Yes, Georgia, agree to grant the variance.
okay, and Susan, my vote's yes also. All right, so this area variance is granted.
Okay, thank you.
Thank you.
Okay.
All right, Marcy, just to catch you up, we have two, or actually three public hearings at our next meeting, one on Hill Street, and then two consecutive ones for the property on Main Street.
Mhm.
The first one on the one on
Sorry,
Main
I
Street.
couldn't quite hear you.
Oh,
Could you
shit.
please repeat?
Sorry, Siri's yelling at me. Okay, I'm sorry.
Okay, the one on Hill Street is pretty self-explanatory. The one on Main Street is kind of a two-parter. We'll initially have an area variance to consider whether a single-family dwelling can be in a, let's see, so that whether you can have a short-term rental in a three-family dwelling, basically. And if that was granted, then the second would be for a special permit. But everything else, I don't think there's anything new that came out in the discussion other than what was part of the application.
Mhm.
Except there was some, I did, and maybe you can kind of explain this a little bit at the next meeting too. I did try to summarize in our work group where we were part of the effort to come up with all these changes and also the revisions to the zoning map, that it was a very intentional change
Right.
to reduce the number of, long-term, to reduce the number of short-term rentals and claw back some of the long-term rentals. We also talked about the map question, which Bob raised, and I don't know if you remember, but I remember
Question,
discussion.
wait, map question?
Well, he attaches as one of his arguments for the appropriateness of this, of what he's requesting is the kind of mixed use and a lot of business use.
Oh, right, yeah, now I remember that, yeah.
And I do recall from our meetings when we are redoing the, drawing the map, raising that same question, particularly on the south side of Main Street, but that it was not determined that it was the consensus is that's what should be done.
I had one question about that. Who is the owner?
It's still, apparently there's a contract agreement for the Sanders, but it is,
Yeah, who has signed on the dotted line? Who is the owner?
current owner is an LLC with Bob Birch and Bob Schlatter.
Okay. So anything we give to them, technically it's all going to change hands and we're hitting the reset button.
So is that
One
why they
concern-
listed the applicant name?
Okay,
Well-
that's why
Really?
I have a slight concern that I feel that the owner is not applying. The current owner is applying so that he can do this for the subsequent owner. The price of the house is in the mix, is in the middle of this. So I feel this has the appearance of some impropriety and I'm not comfortable with it.
I think we've had situations before where people have had contingency contracts, where they needed a variance or they needed something in order, before they proceeded through with the purchase.
I know, and
That's my understanding of this situation. I don't really see it different than that.
I see the difference. There was the ones on the corner of someplace, Scott, what's his name? Who is the financial, used to be at the gym, he's a financial
Wasn't it for a home
advisor.
office though? That was for a home office, right?
Okay.
Well, it was for a home office, but it was before he owned the.
Right, and he wasn't going to be living there. It was going to be his sister or child or something.
Daughter,
Right, but if I recall correctly, we dismissed it out of hand because he didn't own it. And I don't like this. I'm
Well, I mean,
sorry. I don't like it.
I guess it seems like a reasonable thing for a prospective owner to make that as a contingency of the purchase. I guess I think if it
Yeah,
was.
but look who is writing the impassioned letter.
Oh, I understand that.
The seller. I don't feel good about this. I'm sorry.
Can I ask a question in my
Sure.
naivete with the entire process? What has been the standard operating procedure for cases where an applicant was separate from the owner when they applied and then the ownership changed hands during the period where the permit was granted? Is there precedence there? Is in theory, if there's an owner change, does there need to be a new permit granted?
This is, we don't have a precedent because this is a brand new law. There was a time when I could get a permit today, sell the house to you tomorrow, and the permit would convey to you. We went to great lengths to change the law so that that did not happen, because we want to encourage, for various reasons, but we deliberately changed the law so that that did not happen. And, you know, it's the true honest to gosh owner that has to apply for this, and it doesn't convey. And I don't like the way this is coming down.
The actual applicant for this application though are the prospective buyers.
The prospective buyer, okay, but let the record show, they don't own it yet.
Right.
And I feel that my vote is going to affect the selling price. If I say yes to this, Bob Birch gets more money. If I say no to it, then this is not a business. This changes the proposition. This is a different, it's a money generating property. I'm sure it's being advanced that way. And if I don't give them if I don't vote for a variance to allow a transient rental where we've gone to all this trouble, and he ought to know this, to set the law up the way we set it up. If I don't vote for it, then I'm like denying him his purchase price. I
don't know any other
don't
way.
like being there. I don't like this.
I don't know any other way they can handle it other than this, because obviously the owner or the potential purchasers wouldn't buy it. I mean, I assume that they wouldn't necessarily even qualify for the loan or whatever without the without the right to do the short-term rentals. I mean, I feel like we can go back to the law and back to the intent of the changes and either enforce it or, we have to have a really good reason not to enforce it, because it was very intentional.
Yeah, I mean, I don't
All
see
those
where
changes.
this thing, I mean, I don't,
Irrespective of who the owners are and
Yeah.
all that kind of stuff, I
Okay.
think we can go to the meat of the issue.
yeah, I mean, I think my own feeling is that if I were these parties, I would look at the law and say, I'm wasting my time going to the ZBA.
Well,
I mean, you can go for anything, I get that, but we have been stridently clear about this.
Marcy,
So,
I'll interrupt you for 1 second, because one of the things that Bob Burt said a couple of times was that he talked to Martin, and that he's saying that Martin is agreeing with him that the law as written is not, that's what Bob Birch is saying.
well, we'll get that, I'll get that in Martin's mouth. Martin has been misquoted before.
Yes, I'm just telling you, because you
I know.
I'm not saying that's true. I just want you to know that.
I think that it was not so much on I think it was back to the question, which you remember maybe, Marcy, from earlier changes to the law, of kind of whether when you discontinue a use or, when something like a short-term rental expires uniformly, the kind of amortization question of people having a right to for a certain period of time, recover their investment. And so
Sorry.
because the last time when the law was changed, I think that was the kind of premise that whole issue was dealt with. This one was different. It's, you can hold a property for 50 years as long as you continue to own it and operate it, or you sell it next month and you lose it. So it's like a completely spongible kind of link, term. But I think that's specifically what Bob was talking about. I did not understand him to say that Martin had weighed in any way on the validity of, the way the law was written to restrict it to single family homes with accessory apartments and that kind of stuff.
Can I ask another question?
Sure.
Sorry.
Absolutely.
So I'm guessing then, based on the fact that we've changed the laws so that applicant and owner are now two separate items to prevent the owner from just selling it and being based on the applicant, was that the point?
No, I'm just saying in this case, it appears we have that the owner is applying for it and wants to pass it to a new owner. Now, I can understand the argument that, well, he's just setting it up in their name. He's talking for them, but.
I mean,
it-
they were on the call
proceeding.
tonight too. Both Bob and Dana and
Uh-huh.
Sean were on the Zoom call.
Yeah,
I'm sorry, I'm like, is this the application that has been kind of in place and would have been in place the last time he'd applied for the variance?
The
No. Or
the
application
permit,
form, you
rather.
mean? You
It
mean
was
the
the
act-
law was.
The application form is exactly the same.
Okay,
The only thing different is when Bob Birch applied, it was considered or called a tourist accommodation special use permit.
okay,
It did not have restrictions that we have since added to our short-term rental special use application. One of the things that we've added is a 3-year time period that if you get this short-term rental permit now, you only get it for 3 calendar years. You then
Okay.
have to reapply and meet all existing codes at that point. Whereas when he got his tourist accommodation special use permit back in 2015, technically there was no time limit set and it did not specifically go to an owner per se, it went to the property. So up until the law changed, if that property sold, the special use permit went with it. So I
Okay.
could sell my tourist accommodation and the next buyer could just move in. And as long as they weren't changing anything and met the requirements, they could operate a tourist accommodation.
okay. So basically they're asking for this permit because we've changed the laws, making so that the new owner has to have their own permit versus the property itself, kind of?
That's
think-
the objection I'm raising. The law has changed in other ways too. This is a multifamily house. The other thing that changed about the law was that we would only allow transient rentals in single family homes. So now he's asking for a variance away from that. That's what he's asking the variance from, really.
Right.
Correct.
And so,
It's-
we also went to great lengths to do that. So that's what he's doing. So I've lost my train of thought.
No, I
But
think, I mean, I think
in
it's,
other words, I know my train of thought. So in other words, Dana Leonard is buying this thing. She has rentals in it, but the new law would encourage her to have long-term rentals, not transient rentals.
Okay,
And so she can still rent out, apartments on a long-term basis. She can't, according to the law now, the law doesn't allow them in anything but a single family home. So this application is coming to us and saying, hey, give me an exception to that. Give me a variance to that. I would still like to rent to transients.
I mean,
But
so it
my
sounds
own
like this is gonna
feeling
be a
is-
precedent kind of thing. This is gonna be
So-
happening to
Bingo.
properties changing hands that have had these permits prior to the change.
Maybe.
law
This
change.
is, who knows, but this is the
Yeah.
first real
I
big
was-
deal that's come up.
I would say it would be a very major precedent in complete opposition to all the intent of the law changes.
Yes.
The only other property that has changed hands that had an existing tourist accommodation special use permit was 21 Glen Avenue. It was an existing 3-family, similar to what Bob Birch currently owns. They proceeded to go through the route of getting rezoned because they butt up to the commercial property along the railroad tracks. So they were hoping to go from a residential zone to the commercial zone because the commercial zone did not have the single family stipulation inserted into that section. They were denied. The property has since been sold and it is now strictly, I think they have a long-term contract with Bassett to rent all the apartments.
Mhm.
So we did lose one 3-family tourist accommodation already, special use permit.
And that was our intent to encourage more long-term rental.
Understandably, yeah.
I mean, and actually, I would say to go back, like when the law first started, the demand was completely different than today. And tourist accommodations were most commonly traditional B&Bs. And that's really what the law still allows, encourages. The only time a single family house with an apartment could be considered for a tourist accommodation or a short-term rental is if it's an apartment within the structure of the house. So, so all the things, there are several 3 and 4 family dwellings probably within the village that have an owner that lives there and rents out the others short-term because they have a special permit for that. When that sells, it will have to be long-term, which is exactly what the kind of Birch situation is. So the goal was to, over time, recover a lot of those apartments from being primarily used for short-term accommodations so that they're long-term accommodations.
I mean, the one thing that Bob did point out, and I'm not pushing it one way or the other, was the fact that he strictly did short-term during the 3 summer months or whatever, and he had no problem renting out the remainder 9 months, the rest of the year, to nurses or the students and stuff like that. So technically, it wasn't sitting vacant as, a short-term rental that couldn't be used. So he was doing both accommodations for both short and long.
Right. Yeah, and that's good for the village, obviously, also, but they could be rented to nurses in the summer and students in the winter too. I mean, there's all kinds of ways to kind of add up to be a virtually year-round rental.
Lots of options like that though in the village with those existing short-term, like those permits. When, and Vermont, and again, forgive me, my brain is melted from the past couple of weeks here. When did this change? When did this law change here?
A little over a year ago, I think.
Okay.
2018.
Just as you were coming on, I think.
Okay. I think I personally would be interested to hear what Martin has to say about the legality of these changes happening in that period post change, and about.
I mean, it's a past law.
Yeah, and he reviewed it.
Right.
Because he's been the village attorney during that whole time.
Right.
I think the question that maybe you're referring to is Bob had raised, and Martin had mentioned this to me also, that there is some case law about this kind of the way that we structure the laws changes are structured. There may be case law that would argue that that was not a good way, or that's whether it could be overturned. I don't really know that extent, but that typically, when you take away someone's right basically to operate a short-term rental in this specific case, you should give them a certain number of years after the law changes for them to kind of recover their cost. Before, you would never say effective, next month or next year or whatever, you can't do this any longer. You have to kind of have some reasonable time for people to recover their investment. It doesn't have to be forever, but it's, but there's laws that kind of establish what's reasonable for that. These changes to the law did not handle it that way. They handled it, giving people time, but only until they sold. So you can have as long as you want, as long as you operate it. You can have 10 years or, 5 years or 2 years or whatever, as long as you continue to operate it, but you can't sell it and kind of carry that right to continue to operate it over to the next owner. They have to start from scratch with whatever the law says at that point. And the reason why it was set up so that new special permits going forward are only good for kind of 3 years, and then you have to start it from scratch again, is because the one part of our law that has changed the most over the last 15 years have been related to tourist accommodations, because the pressures have changed and the village tends to play kind of catch up. And so we're always kind of trying to deal with, changing things in response to problems that have arisen. In this case, the primary problem was that we just have we've eroded so much of the apartment stock for short-term rentals that there really isn't enough apartment stock. So trying to recover that, and this was the kind of approach taken. I know that Martin reviewed this as he reviews every change to the law. And whatever Bob Birch is referring to, I think was even more recent case law. So it could be a situation that if we make a decision, then it's not in his favor, that Bob Birch would, take another case and against the law in general, basically, and it would, be something that Martin would have to argue and might win or lose, who knows? But I think all we can do is apply the law as it's written, because that's our job. And so we would just review this in the context of our understanding of why the law was changed, but also the general criteria we always review with any kind of area variance.
Okay. In that case, I guess for me, it doesn't matter who the property owner is then, as long as it's the applicant, they're applying for their own new variance.
If the area variance was granted, they would apply for the special permit. Absolutely. Yeah, I think what you were saying, Marcy, was that basically the property conceivably has two separate values, one with its current right to rent short-term to the current owners. And
I have a concern about that, yes.
right. And but whatever, I have no idea what the sale price is, but and I don't think that weighs into our decision at all either. I think that was understood in the law changes, that some properties were not going to have the same value going forward as they would, after a change of ownership, as they would have before. But I don't know, I just don't know any other way since Shawnee and Dana are listed as applicants, that's exactly what they are. And Bob Birch is listed as the owner, that's exactly what he is. He happens to be a lawyer, so he's kind of arguing the case for them. But I still think it's a reason, we have to have a way for people who have made a commitment to purchase contingent upon a decision to be able to kind of go through the process and get that decision before they.
I see what you're saying. I get that. And
Yeah.
I see what you're saying. However, I am not saying that this should influence our decision or can by law. What I'm saying is it has the appearance of impropriety, and I feel that our decision, we do not know what's going on behind the scenes, but it's a reasonable thing to say that, okay, if I can't rent to transients, I'll give you the house for $100,000 less. It is not unreasonable to think that those discussions are behind this. They may not be.
But that's okay.
Yeah.
But,
We can make our
I
decision.
feel that, okay, maybe this is just a rant and it has nothing to do with anything, and I'll not bring it up again. But I am just saying, I feel that it's an appearance of impropriety, and I feel that it's the appearance of, putting the ZBA, inserting the ZBA into a financial negotiation. It just, like I say, the appearance. I'm not accusing anybody, but
Yeah.
that's the sort of a legal standard, the appearance of impropriety. And
I don't honestly see why we have the appearance, because we know nothing about any of their discussions or the price of the house or whatever.
I know, but we're just sort of innocently being inserted in there. That's what I'm saying. It's not our appearance, it's their appearance.
Oh, okay.
And I think that we are innocently, I think the ZBA, not us, the ZBA is innocently being dragged into a negotiation, a financial negotiation.
I guess to me, speaking as I own property up the road, we've gone through the same sort of things over the years. Like as a buyer would, yes, want to know whether or not this was going to be allowed.
Yeah.
Obviously, the seller would like it to happen, but as the ZBA, I don't care. Like if we grant it
Right.
for them based on the merit of their application, whatever happens after that is not really our problem. And I think we are going to see this going forward, especially with the property changes. And there is a bit of a shift happening generationally right now, especially.
It's also troubling to me, though, that there is a, for want of a better word, sort of an underlying little niggling little threat that there will be an Article 78. And, you know, I
didn't hear that. I'm
like it.
sorry.
An Article
Legal
78
challenge.
means that they'll take us to court. The next step, if somebody wants to appeal our decision, they take it up, and, you know, it's referred to as Article 78 because that's the portion of the law that refers to this. So it's almost like he's got like a little niggling threat in there that I don't like the law. The law is wrong for this reason. It's capricious. He threw that word in, and you know, I'm not happy about this whole thing.
Yeah, but I don't know what we can do except just what Georgia said, which is kind of look at it on its own merits. If, you know, if they, any decision that we make, somebody, you know, could have an Article 78. We really have never, I mean, certainly there have been challenges to our decisions before,
Yeah.
and Martin argues them, and in recent years they've stood. So I think that's, you know, I think we have a, you know, I think we do it carefully, and that's the whole point of our decision making.
Okay. All right.
I would
Well,
just,
I've said
you know,
my piece.
pardon?
I've said my piece. I'm
Yeah. Yeah. No, I
I'll let
think,
you off the hook now.
Yeah, I get that it might be a concern, especially if, again, Susan, you said that Martin has mentioned that there could be, based on recent case law, a potential for them to not agree, like to go up against the decision, but that's
but
Martin's problem.
maybe Jane, you see this differently, but it seems to me my understanding of Bob's reference to the kind of legality of a portion of our law is actually not, I mean, I don't even know if that's in Article 78. I mean, it seems like
Right, I don't think he's
basically
not gonna,
about the law itself, the way it was written, not about any decision or how we would make a decision. I think
Yeah.
if he decides to follow through, I think legally, he isn't going to appeal the current decisions that you guys are looking at right now. He's going to appeal the fact that he has what he considers a existing special use permit that theoretically goes with the land, that the permit itself specifically does not have an expiration date on it. And he would argue that even if the law changes because it was an existing permitted use, special permitted use, that even if the law changes, it doesn't necessarily become void. So I think that's more what his argument going forward
Right.
would be,
So he's basically saying to us that he's dismissing our law. I don't.
no, he's
Tell me to shut up.
no, I mean, I think all we have to do is, I mean, the only thing I would say is that this area variance request is potentially way more significant, or, you know, significant, I guess I would say, than the average one that we get, because the ramifications for other properties, you know, the precedent that we would set would be very serious.
Mhm.
it's very different than looking at individual property and the limitations of an individual property. I think it would be a very serious precedent. And I think we need to look at it in that, with that seriousness.
Is there any language in the zoning laws themselves that state any official updates hold null and void the prior contract or whatever? Is there potentially anything like that that
Wait,
would,
say that again? I don't understand that.
I'm trying to think of like a comparable thing, but like in the zoning laws or anywhere on permits saying any changes, like legal changes made hold the prior contract or anything put in under the prior contract.
Yeah, I don't,
No?
not that I know of. I mean, even in our special permit placard, is there even a place even for an expiration? I know
Yes,
that
there is.
there is, okay. So,
And it does not have, I mean, the one that we have in our file does not show any kind of an ending date on it. And like I said, we specifically changed our village law to state that this existing tourist accommodation special use permits will become void. Now, I've been
Okay.
trying to do research online to look at different things. I found a couple different things that, one talks about the fact that a special use permit extends with the land. So at that point, does that mean that you even, you aren't allowed to say that it ends or make it, void? So that's why I'm saying, I think the argument that he would proceed with in court would be that he has an existing legal special use permit that, he doesn't understand why we can, now say it's void. That would be the argument, not that you necessarily denied his request for this new one. And if he does proceed, pursue that and he wins, then that gives all the other existing tourist accommodation special use permits precedence for, going forward to say that there shouldn't become void.
right,
So,
That's true, even if you grant it, you get set the same precedent, basically. One's just the legal thing and the other's
Right.
what you did.
I mean,
Yeah.
basically, this is a test of our law. I mean, and we don't have the law doesn't have an overarching guideline that says such and such declares another contract null and void. But we have this piece in our transient rental thing that says it no longer conveys with the house. It's with the owner. So anyway, okay. I'll be quiet now.
No, I think you're right. I mean, it depends on how we choose to interpret what the law specifically says versus like the intention versus the letter, in a sense.
No, in this case, it's pretty much the letter and the intention.
well, it's both, yeah.
I suppose.
Yeah.
Jane, I know that when local laws are passed, isn't there kind of a summary statement for the purpose of it?
yes,
Can you find that for those changes and circulate
Sure.
that to the board members?
sure.
Okay.
And I'll send out all my stuff that I've been trying to track down as far as special use permits and stuff. Like I said, I find some that basically make it sound like they're permanent, you can't do anything with them, period. And then I found some that basically state, the short-term rental special use permit guidelines that we have created, I don't argue they are definitely legal as far as being able to put restrictions on them for ownership and time periods and things like that. But it also looks like if there aren't specific conditions set at the time of granting, that you might not be able to get rid of them. So like I said, I'm looking at,
Yeah, I don't think that would win, but we'll see.
I mean, I think it's a very different thing when you're saying all special permits, you're not picking out individual ones, but
Right.
the way that was handled was it applies evenly to every single existing special use permit. So it doesn't, that seems like the only way you could approach it in a reasonable way.
I gotta step
All right.
away for 1 minute.
Okay, well, I think except for the minutes, we'll go on to the minutes.
Okay. I had a couple things. Oh, Michael, I found, thank you. At the bottom of page 4,
Yeah.
you said something about, wait a minute, let me find it. I was so excited.
Okay.
Bottom of page 4. It's kind of a few lines up from the bottom. 1, 2, 3, 4, 5, 6, 7, 8 lines from the bottom. It says, consequently, there were a series of mistakes affecting the minutes. It was
Oh, well.
affecting the minutes.
Affected with an A.
Thank you. You made my day.
I thought that was a helpful discussion or description of that confusing situation.
Oh, yeah. Oh, no, the writing was great.
Yeah,
Oh, yeah, you spelled
Right.
out something
spell
absolutely
it properly. Yes,
totally
sure.
confusing. But so that's why I'm saying you were just, you gave me something to play with though. Thank you.
Okay. Change it though. Okay.
And there was a further up under the Oxley thing.
Tell me where it is, Marcy, because I don't have a copy of the
I know.
minutes in front of me.
Oh, okay, I'm working on it. I'm looking at my phone, I'm looking at my notes.
Oxy is the first 3.5 pages.
I can
I
pull
think
them up
we were
on the
going
screen if you want.
through- Yeah, we were going through the questions and, you said something about, oh, yeah, it was under area variance criteria responses. It was under question 1, and it says A1, no, believes it will not change the appearance of the neighborhood. Board response, Susan Snell and Marcy Schwartzman, letters submitted by neighbors state that they believe it will impact the neighborhood. Why is that the board response? Or I don't get that. Because so
Well,
what? I
that's
was just,
because that's what Susan or somebody said. It was just really somebody in the board stated that
oh,
read the letters and
because
that's
if I said that, yeah, I was just acknowledging what I heard. I don't want that to be interpreted as like, that meant something to me, I guess. I don't know. I'm overthinking it. Okay, I'm sorry. I'll move on.
That was on page 2, by the way. Okay.
Okay,
Do you
and
want me to
then-
change that or leave it or what do you want?
No, you just told me to be quiet.
Okay.
Now, on the page.
Well, you could get rid of the Susan Snell and Marcy Schwartzman and just leave it
Yes,
as
thank
letters
you.
submitted by
Thank you.
neighbors.
Thank
So
you.
just eliminate the Susan and Marcy.
Okay.
Okay. And then the other had to do with what it was above that on page 1, where we were looking at the where's I believe the McNelly letter. Where it said something that something about the garage is already in the setback. But it was
Oh yeah,
legally-
there. The garage on the X was previously built within the setback.
That's
Yeah.
under the next,
But wasn't that given, I mean, isn't that legal? Wasn't that given a variance?
That was just in the letter.
right.
That was in the letter, okay.
It was given a variance, but it actually was built beyond what the variance was granted.
Oh, okay. So
Once,
okay.
they
so
realized,
then-
it was found out once the survey was done.
But this
So
isn't
he's
what
in-
you said. This is just what was in the letter.
Oh, no, I understand, but somebody will read this and I just want to make sure that the implications are correct. And yes, what that implies is that, you know, they can't be trusted. I don't know what he's implying that, okay, but move on from that. I'm okay with that then.
Okay,
And that's all I've got.
that's it?
Yep.
Okay, the change affecting to effecting or affecting to affecting, and then,
Yes.
um,
And then
and
taking.
get rid of the fact that you and Sue said that other thing. or
Right.
Okay,
Okay, so I'll make a motion to accept the minutes as amended, as corrected.
All right. Is there a second? I'll second. Any
who
further?
seconded? Who
I'll
seconded?
second. Susan,
Oh, okay, thank you.
is there any further discussion?
No.
Okay, vote on the minutes.
Marcy?
Susan, I vote yes.
I vote yes. I think Dave was here. We have to unmute Dave.
Dave, you're muted, Dave. Actually, I think that Georgia might be muted too. I can't hear her.
No,
David,
Georgia-
yes.
No, I'm
not-
just
Is
whispering.
Georgia there? I don't think Georgia was there.
Oh, you're right. I'm sorry.
I'm just
Georgia.
whispering.
Okay. Dave, did you
Dave
vote?
voted
David, yes.
Okay, all right. So we have 3 affirmatives
Georgia abstained.
and Georgia wasn't there, so hers will be an abstention.
Okay,
All right. Anything else?
I would like to say sorry for having been very, very absent. Things have been really, really horrible at work. So
Oh, yeah. We're glad you're back. You asked good questions.
thank you. Appreciate that.
All right, we'll adjourn. Thank you all.
All right, good
Bye.
night.
Bye.
Night.
Night.
night,
Night.
see you in a month.
Bye.
Bye. All right, I'm stopping that. I'm ending, I'm stopping.